About another set of standards used by OAL in reviewing rulemaking files. These are the authority and reference standards. As you may recall, California's Office of Administrative Law, the OAL, unless there's a statutory exemption, is required to review rulemaking files developed by executive branch state agencies when they adopt, amend, or repeal a regulation. And under California's APA, the Administrative Procedure Act, that's found in California's Government Code, there are 6 statutory standards used by OAL to evaluate regulations. These 6 statutory standards that OAL is required to use to evaluate regulations are necessity, authority, clarity, consistency, reference, and non-duplication. Recall that OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive content of the regulations. Also, OAL has 30 working days in which to review the rulemaking record to determine whether the record demonstrates that the rulemaking agency satisfied the procedural requirements of the APA. In taking a little closer look at the authority standard and the reference standard, first we ask, what is authority? It means the provision of law which permits or obligates, requires the agency to adopt, amend, or repeal a regulation. What is reference? It means that the statute, court decision, or other provision of law which the agency is implementing, interpreting, or making specific by adopting, amending, or repealing a regulation. The Office of Administrative Law, OAL, has adopted a series of regulations for purposes of the APA, including further defining the 6 standards of review. So these are found in Title I of the California Code of Regulations, the CCR. Section 14 concerns authority and reference, and it provides that in reviewing a regulation for compliance with the authority and reference requirements of Government Code Section 11349.1, OAL is required to apply several standards and presumptions. First, authority is presumed to exist only if an agency cites in its authority note proposed for printing in the CCR, again, the California Code of Regulations, a California constitutional or statutory provision which either expressly permits or requires the agency to adopt, amend, or repeal the regulation. Or it cites a California constitutional or statutory provision that grants the power to that agency, or it impliedly permits or obligates the agency, again, to adopt, amend, or repeal a regulation in order to achieve the purposes for which that authority was granted. Reference is presumed to exist if an agency is empowered to implement, interpret, or make specific a California constitutional provision, a California statute, a federal statute or regulation, or a court decision or order is cited in the reference note proposed for printing in the California Code of Regulations. An agency's interpretation of its regulatory power, as indicated by the proposed citations to authority or reference in the CCR, or to any other supporting documents contained in the rulemaking record, is generally viewed as conclusive, except in certain specified circumstances. And again, check Title I of the CCR, Section 14. Note finally that the citations of authority and reference for each regulatory section which has been adopted or amended and submitted to OAL for filing with the Secretary of State must appear at the end of each section of the proposed rulemaking. And again, that rulemaking is to adopt, amend, or repeal a regulation.